The Senate Judiciary Committee hearing room hummed with tension as Senator Josh Hawley leaned forward toward his microphone, a dismissive smile playing at the corners of his mouth. For the past 20 minutes, Representative Jasmine Crockett had been methodically dismantling his proposed constitutional amendment with precise legal citations and historical precedents. "Representative Crockett," Hawley said, his voice carrying throughout the chamber, "I appreciate your enthusiasm, but I think there's some confusion here. My Yale law degree and Supreme Court clerkship suggest I might understand constitutional jurisprudence a bit better than someone from the University of Houston Law Center. Perhaps in Texas they teach constitutional interpretation differently than at the institutions that have shaped American legal thought for centuries." A ripple of uncomfortable murmurs spread through the gallery as committee. Members exchanged glances, surprised by the personal attack from the Missouri senator. Representative Crockett sat motionless for 3 seconds, her expression unreadable as she studied the senator. Then she reached for her microphone and delivered a response that caused veteran legal correspondents to freeze mid-keystroke. "Senator Hawley," she began, her voice measured yet precise, "while you were writing academic articles at Yale, I was successfully arguing before the Fifth Circuit on the very constitutional provisions we're discussing today. When you clerked for one justice, I was litigating cases that established precedent across 3 circuits, and when your amendment cites Harrington versus California, it fundamentally misinterprets Justice Douglas's opinion, which I know because I personally interviewed Justice Douglas's last living clerk while preparing for Jenkins v. Texas, which I won 8-1 before the Supreme Court last year. So yes, perhaps we do teach constitutional law differently in Texas, with an emphasis on practical application rather than theoretical credentials." The room fell silent. Hawley's confident smile vanished as committee members straightened in their seats, suddenly alert to the significance of what they were witnessing. Before diving into this extraordinary confrontation between 2 of America's most qualified legal minds, comment where you're watching from, and don't forget to subscribe so you won't miss our latest political analysis. Representative Jasmine Crockett had built her reputation in Congress through substantive legal expertise rather than political grandstanding. A graduate of the University of Houston Law Center, where she had served as editor of the Law Review, Crockett had practiced constitutional law for 15 years before entering politics. Her legal career wasn't merely academic, she had successfully argued major cases before multiple federal circuits, establishing significant precedents in voting rights, due process, and equal protection jurisprudence. Before joining Congress, Crockett had been named to the prestigious American Law Institute and had co-authored 3 amicus briefs for Supreme Court cases, 2 of which were specifically cited in majority opinions. Her scholarly articles on constitutional interpretation had appeared in the Harvard Law Review and Stanford Law Review, despite her not being affiliated with either institution. "The Constitution isn't an abstract document," she had explained during her first campaign. "It's a living framework that directly impacts Americans' daily lives. My approach to constitutional law has always focused on practical application to how these principles protect real people facing real challenges." At 42, Crockett maintained the precise attention to detail and rigorous analysis that had characterized her legal career, approaching congressional hearings with exhaustive preparation and a command of both constitutional theory and practical implementation. While some colleagues relied on staff briefings, Crockett was known to spend evenings personally researching the historical context and precedential foundations of pending legislation. Senator Josh Hawley had forged a different path to legal prominence. A graduate of Stanford University and Yale Law School, Hawley had clerked for Chief Justice John Roberts before entering academia as a professor at the University of Missouri School of Law. His scholarly work on constitutional originalism had earned recognition in conservative legal circles, and he had leveraged this expertise first as Missouri Attorney General and then as a U.S. Senator. Hawley's proposed constitutional amendment, the subject of the current hearing, would establish new limitations on federal authority over state election procedures. Titled the Electoral Federalism Amendment, the proposal sought to codify a stricter interpretation of states' rights in election administration while limiting federal oversight. This amendment would restore the founders' vision of electoral federalism, Hawley had explained when introducing the proposal. It reaffirms that states, not Washington bureaucrats, should determine how their citizens elect representatives. The specific hearing that brought Crockett and Hawley into direct conflict was a joint session of the Senate Judiciary Committee and House Judiciary Committee, an unusual format reserved for constitutional amendments with significant bipartisan interest. The amendment had gained support from states' rights advocates while raising concerns from voting rights organizations and constitutional scholars about potential impacts on equal protection guarantees. As the hearing began, few anticipated the dramatic confrontation that would unfold. Both Crockett and Hawley were known as serious legal thinkers who generally focused on substantive arguments rather than personal attacks. But beneath their professional demeanors lay fundamentally different approaches to constitutional interpretation, differences that would soon erupt into one of the most memorable exchanges in recent congressional history. Chairman Durbin called the Joint Committee hearing to order at 10 a.m. sharp. Today we examine S.J. Res. 42, proposing an amendment to the Constitution regarding election procedures. Senator Hawley, as the primary sponsor, you have 15 minutes to present your proposal. Hawley approached the podium with the confident bearing of a former Supreme Court clerk. For 15 minutes, he outlined his amendment with references to the Federalist Papers, early constitutional debates, and founding-era understandings of federalism. His presentation was articulate and scholarly, designed to appeal to originalist interpretations of constitutional structure. The founders clearly intended states to determine their own election procedures. He explained, "This amendment simply restores that original understanding while preserving fundamental rights." Section 1 establishes that states have primary authority over election methods. Section 2 prohibits federal regulations, except where necessary to protect constitutional rights. And Section 3 requires a heightened judicial standard of review for federal interventions. Hawley cited historical precedents supporting state autonomy in election administration. From the ratification debates through early constitutional practice, the evidence consistently shows that the founders viewed electoral procedures as fundamentally state matters. This amendment doesn't change the Constitution, it restores the Constitution's original meaning. When his time concluded, Chairman Durbin opened questioning. "Representative Crockett, you are recognized for questions." Crockett approached her microphone with the measured confidence of an experienced constitutional litigator. "Thank you, Mr. Chairman." She looked directly at Hawley. "Senator, I appreciate your historical references to the founders' intent. However, I'm concerned that your analysis overlooks significant constitutional development since the founding era, particularly the Reconstruction Amendments." She opened a well-worn copy of the Constitution. Article 1. Section 4 states that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations. This explicit reservation of congressional authority seems directly contradicted by your amendment's limitations on federal oversight. How do you reconcile this textual inconsistency? Hawley appeared momentarily surprised by the direct textual challenge but recovered quickly. Representative Crockett, the original understanding of that provision was far narrower than modern interpretations suggest. Contemporary records indicate the founders intended congressional authority as a fail-safe against state inaction, not as general regulatory power. "That's an interesting interpretation," Crockett replied, "but it seems inconsistent with both the plain text and early implementation." In 1842, Congress enacted the first federal requirement that House members be elected from districts, overriding states that elected representatives at large. The Supreme Court upheld this federal action in Ex parte Siebold, establishing that when Congress acts under Article 1, Section 4, its authority is paramount to the states. She continued methodically. "More fundamentally, your historical analysis appears to stop in 1789, overlooking constitutional transformations wrought by the Civil War amendments. The 15th Amendment explicitly grants Congress enforcement power regarding racial discrimination in voting. The 14th Amendment's Equal Protection Clause has been consistently interpreted to authorize federal intervention when state election procedures discriminate, as affirmed in Harper v. Kemp, Virginia Board of Elections, and subsequent cases." This historically nuanced critique delivered without notes revealed Crockett's deep constitutional expertise. Hawley shifted approach, moving from historical arguments to textual analysis of his amendment. "My amendment preserves these constitutional protections," he countered. "Section 2 explicitly allows federal action where necessary to protect constitutional rights. This simply establishes a proper balance between state authority and federal oversight." "I appreciate that clarification," Crockett responded. "But the language in Section 3 seems to undermine that balance. It requires courts to apply strict scrutiny to federal election regulations, a standard typically reserved for potential constitutional violations. This effectively treats congressional exercise of its explicit Article 1 authority as presumptively unconstitutional inverting the constitutional hierarchy established by the Supremacy Clause. She displayed the amendment text on screen, highlighting specific language. Furthermore, Section 3B states that courts shall not defer to congressional findings of fact when reviewing federal election regulations. This directly contradicts established separation of powers principles dating back to McCulloch v. Maryland, where Chief Justice Marshall established that Congress has latitude to determine necessary and proper means for exercising its constitutional powers. This precise legal analysis, identifying specific constitutional contradictions, rather than general concerns, seemed to catch Hawley off guard. He responded with increasing defensiveness, shifting from constitutional substance to procedural objections. Representative Crockett, with all due respect, you're misinterpreting both my amendment and the constitutional principles it embodies. The amendment preserves congressional authority while preventing overreach. I'm struggling to reconcile that assertion with the amendment's actual text, Crockett replied. Section 1 states that the power to determine the manner of holding elections is reserved to the states. This absolute language directly contradicts Article 1, Section 4's explicit grant of congressional authority to make or alter state election regulations. She continued without referencing notes. This contradiction creates a fundamental constitutional problem. Under Article 5, amendments can change constitutional provisions but cannot create irreconcilable internal contradictions. The Supreme Court established this principle in Sprague v. United States, noting that amendments must be integrated into the constitutional whole rather than creating isolated provisions that contradict foundational structures. This invocation of a relatively obscure constitutional doctrine delivered with the precision of a law professor visibly frustrated Hawley. Rather than engaging with the substantive legal critique, he attempted to dismiss it by questioning Crockett's credentials. Representative Crockett, Hawley said, his voice carrying throughout the chamber, I appreciate your enthusiasm, but I think there's some confusion here. My Yale Law degree and Supreme Court clerkship suggest I might understand constitutional jurisprudence a bit better than someone from the University of Houston Law Center. Perhaps in Texas they teach constitutional interpretation differently than at the institutions that have shaped American legal thought for centuries. The personal attack, unusual in a committee focused on constitutional in Texas substance, created a palpable tension in the room. Several committee members appeared startled by the shift from legal debate to credential comparison. Representative Crockett sat motionless for 3 seconds, her expression unreadable as she studied the senator. When she finally spoke, her voice remained measured but carried unmistakable authority. Senator Hawley, she began, while you were writing academic articles at Yale, I was successfully arguing before the Fifth Circuit on the very constitutional provisions we're discussing today. When you clerked for one justice, I was litigating cases that established precedent across 3 circuits. And when your amendment cites Harrington v. California, it fundamentally misinterprets Justice Douglas's opinion, which I know because I personally interviewed Justice Douglas's last living clerk while preparing for Jenkins v. Texas, which I won 8-1 before the Supreme Court last year. So yes, perhaps we do teach constitutional law differently in Texas with an emphasis on practical application rather than theoretical credentials. The response, precise, factual, and devastating in its substance, created absolute silence in the hearing room. Several committee members visibly reacted, some exchanging glances of surprise, others quickly reviewing their notes as if suddenly reassessing the dynamics of the hearing. Chairman Durbin, recognizing the significance of the exchange, intervened smoothly. I appreciate both members' perspectives on these important constitutional questions. Let's continue with questions from other committee members. But the dynamic of the hearing had fundamentally changed. What began as a routine committee session had transformed into a defining moment that legal observers would later describe as the day credentials collided with actual constitutional expertise. As questioning continued, the impact of the exchange between Crockett and Hawley reverberated through the committee room in subtle but unmistakable ways. Committee members who had initially directed their questions primarily to Hawley now increasingly sought Crockett's perspective on constitutional implications. Senator Klobuchar, a former prosecutor, posed a question that reflected this shift. Representative Crockett, given your experience litigating constitutional cases, could you elaborate on how the proposed amendment might affect existing voting rights jurisprudence? I'm particularly interested in potential impacts on Section 2 of the Voting Rights Act. This question focused on practical constitutional implications rather than abstract theory, played directly to Crockett's strengths. Her response demonstrated both doctrinal command and practical litigation experience. Thank you, Senator Klobuchar. The amendment creates several significant tensions with established voting rights jurisprudence, she explained. Section 3's strict scrutiny requirement would fundamentally alter the analytical framework established in Thornburg v. Gingles and refined in subsequent cases. Currently, Section 2 claims are evaluated under a totality of circumstances test to determine discriminatory effects. By imposing strict scrutiny on federal voting regulations, the amendment would effectively reverse this burden, requiring the federal government to prove compelling interest and narrow tailoring for each application of Section 2. She displayed a flowchart illustrating current VRA litigation procedures alongside the changes the amendment would create. This procedural shift would significantly impact cases like the recent litigation in North Carolina State Conference of the NAACP versus McCrory, where the Fourth Circuit identified discriminatory intent in voter ID provisions. Under this amendment, the court would have been required to apply strict scrutiny to the VRA itself rather than to the state's potentially discriminatory action. This detailed, technically precise analysis focusing on specific doctrinal implications rather than general concerns visibly impressed committee members from both parties. Senator Cornyn, a conservative with significant judicial experience, followed up with a question that would have been unthinkable before the confrontation. Representative Crockett, from your litigation experience, how might courts reconcile the amendment's Section 3 judicial review provisions with existing standards for reviewing congressional action under Section 5 of the 14th Amendment? The question opened the door for Crockett to address one of the amendment's most significant constitutional vulnerabilities, which she handled with characteristic precision. That's an insightful question, Senator Cornyn. The amendment creates a direct doctrinal conflict with established Section 5 jurisprudence. In City of Bourne v. Flores, the court established that Congress has broad enforcement authority under Section 5 when addressing discrimination, requiring only that legislation be congruent and proportional to the constitutional violation being remedied. She displayed text from the City of Bourne decision alongside the amendment's language. Section 3 of the amendment would replace this congruent and proportional standard with strict scrutiny for election regulations, effectively nullifying Congress's Section 5 enforcement power in the electoral context. This creates an irreconcilable tension between two constitutional provisions: Section 5's explicit grant of congressional enforcement authority and the amendment's restrictions on that same authority. This nuanced constitutional analysis identifying specific doctrinal conflicts rather than general objections further established Crockett's command of both constitutional theory and practical litigation implications. Throughout this portion of the hearing, Senator Hawley remained uncharacteristically subdued. The Missouri senator, normally quick with responses and follow-up questions, appeared to be recalibrating his approach following the earlier exchange. When he did speak again, his tone had noticeably shifted from dismissive to more substantively engaged. Representative Crockett, Hawley began, his tone now carefully neutral, you've raised important questions about potential conflicts with Reconstruction Amendment jurisprudence. How might the amendment be modified to address these concerns while still preserving the principle of state primacy in election administration? This question, seeking substantive improvement rather than defensive justification, represented a tacit acknowledgement of the constitutional issues Crockett had identified. The shift wasn't lost on experienced committee observers, one of whom later described it as the senatorial equivalent of extending an olive branch after recognizing you've significantly underestimated your opponent. Crockett answered with the same measured expertise she had demonstrated throughout. That's a constructive question, Senator Hawley. The fundamental tension could be addressed by modifying Section 3's judicial review provisions to recognize the distinct constitutional status of legislation enacted under the Reconstruction Amendments. Perhaps language specifying that nothing in this amendment shall be construed to limit congressional enforcement power under the 14th and 15th Amendments would preserve both state authority in general election, administration and federal authority to protect constitutional rights. She continued with specific drafting suggestions. Additionally, replacing Section 3's strict scrutiny requirement with a substantial relations standard would better align with existing federalism jurisprudence while still providing meaningful judicial review. This approach would be consistent with the court's analysis in cases like Shelby County versus Holder, where the court recognized both state sovereignty interests and federal protection mandates. As Crockett outlined these targeted improvements, committee members listened with growing attention. The conversation had transformed from partisan positioning to substantive constitutional analysis, precisely the kind of deliberative refinement that congressional hearings were designed to facilitate but rarely achieved. Chairman Durbin, recognizing the productive shift in the hearing's tone, extended questioning time. I believe the committee is benefiting from this detailed constitutional analysis. As questioning continued, Senator Blumenthal, a former state attorney general, asked a question that further highlighted Crockett's practical legal experience. Representative Crockett, having litigated constitutional cases, could you address how this amendment might affect pending election litigation in federal courts? That's an important practical consideration, Senator Crockett responded. The amendment's Section 4 contains language that could be interpreted to apply retroactively to pending cases. This raises serious separation of powers concerns under the court's decision in Plout v. Spendthrift Farm, which established that Congress cannot retroactively command the federal courts to reopen final judgments. While the amendment doesn't explicitly require reopening final cases, its language that courts shall apply this amendment to all pending cases creates constitutional tensions with Article 3's vesting of judicial power. This analysis focused on practical litigation implications, rather than abstract theory, further distinguished Crockett's approach from Hawley's earlier emphasis on historical originalism. The contrast was not lost on committee members, who increasingly directed their most substantive questions to Crockett. Senator Hawley, recognizing this shift in committee dynamics, made a final attempt to reassert his constitutional expertise while acknowledging Crockett's substantive points. I appreciate Representative Crockett's technical analysis, he stated. While I maintain that the amendment's core purpose is constitutionally sound, her suggestions regarding potential conflicts with Reconstruction Amendment jurisprudence merit serious consideration. Perhaps we can work together to refine the language while preserving the principle of state primacy in election administration. This conciliatory approach, acknowledging the validity of Crockett's constitutional critique, while maintaining his position on core principles, represented a significant shift from his earlier dismissive tone. Chairman Durbin seized the opportunity to promote constructive collaboration. I appreciate Senator Hawley's willingness to consider refinements based on Representative Crockett's analysis. Would the two of you be willing to work together on amendment language addressing these constitutional tensions before our next hearing? Both members agreed, creating a surprising moment of collaboration that committee veterans later described as the most constructive possible outcome from what began as a credential-focused confrontation. As the hearing concluded, the transformation was complete. What began with Hawley dismissively referencing his Yale law degree had evolved into a substantive discussion of specific constitutional doctrines, with both members agreeing to collaborate on improvements. The committee had witnessed not just a personal confrontation, but a victory for substantive constitutional analysis over credential-based authority. In her closing remarks, Crockett maintained the same measured, substance-focused approach that had defined her participation throughout. Constitutional amendments require the most careful consideration, not because change is impossible, but because we must ensure new provisions harmonize with existing constitutional structures. I look forward to working with Senator Hawley to address these doctrinal tensions while respecting the legitimate federalism concerns his amendment seeks to address. As members gathered their materials after adjournment, several committee members approached Crockett to continue discussion of specific constitutional provisions. The deference they showed to her expertise, regardless of partisan affiliation, represented the most meaningful vindication of her approach to the hearing. For legal correspondents covering the committee, the story had transformed from routine partisan disagreement to something far more substantive. A veteran Supreme Court reporter was overheard telling a colleague, "That wasn't just a comeback, that was a master class in how practical constitutional expertise trumps credentials when properly deployed." By evening, clips of the exchange between Representative Crockett and Senator Hawley had spread widely across traditional and social media platforms. What caught viewers' attention, however, wasn't merely the personal confrontation, but the substantive contrast between credential-based authority and demonstrated constitutional expertise. The New York Times legal affairs correspondent captured this distinction in an analysis titled "Beyond Credentials: The Crockett-Hawley Exchange as Constitutional Moment." The article noted that, beyond the personal drama, yesterday's hearing represented something increasingly rare in constitutional discourse, a debate where specific legal knowledge and litigation experience prevailed over institutional pedigree and theoretical credentials. Legal scholars across the political spectrum acknowledged the significance of the size exchange, though they characterized it differently. Conservative legal commentator Oren Kerr observed, Senator Hawley made a tactical error by shifting from substantive debate to credential comparison in an area where Representative Crockett clearly possessed superior practical expertise. The lesson isn't ideological but methodological. Constitutional analysis requires more than prestigious degrees. Progressive constitutional scholar Lawrence Tribe offered a different perspective. What made Crockett's response so effective wasn't just her litigation experience but how she deployed it. She didn't engage in abstract theorizing or partisan positioning. She identified specific doctrinal tensions and proposed concrete solutions. That's constitutional lawyering at its finest, regardless of where one studied. For Hawley, the aftermath required careful navigation. His initial response, a tweet stating that rigorous constitutional debate strengthens our democratic institutions, was widely seen as an attempt to reframe the confrontation as routine committee business. This characterization gained little traction as more people watched the full exchange and recognized its exceptional nature. 3 days after the hearing, Hawley demonstrated political acumen by taking a more direct approach. In an interview on Fox News, he acknowledged, "Representative Crockett raised legitimate constitutional questions about potential tensions with Reconstruction Amendment jurisprudence. While we approach constitutional interpretation differently, I respect her litigation experience and practical insights. That's why we're working together to refine the amendment's language to address these doctrinal concerns." This forthright acknowledgement rather than continued emphasis on his Yale credentials earned Hawley praise for intellectual honesty. A senior legal correspondent noted, "In recognizing Crockett's substantive critique without abandoning his principles, Senator Hawley has transformed what could have been an embarrassing moment into a demonstration of constitutional statesmanship." For Crockett, the aftermath brought increased attention to her approach to constitutional analysis. Law schools requested permission to use video of the exchange in classes on constitutional litigation and doctrinal development. The American Constitution Society and Federalist Society, ideological opposites in the legal world, both invited her to address their annual conventions on practical constitutional interpretation. In an interview on CNN's State of the Union, Crockett maintained her focus on substance rather than personal vindication. When asked about the confrontation with Hawley, she redirected, "What matters isn't where we studied law but how we apply constitutional principles to protect Americans' rights." Senator Hawley and I are now working together to address potential doctrinal conflicts in the amendment while respecting legitimate federalism concerns. That constructive engagement is far more significant than any single exchange during a hearing. This response, prioritizing constitutional substance over personal triumph, reinforced Crockett's reputation as a serious legal thinker, more interested in doctrinal clarity than partisan advantage. The substantive impact extended beyond personal reputations. 2 weeks after the hearing, the Senate Judiciary Committee released a significantly revised version of the proposed amendment. The new draft, officially credited to Hawley Crockett, contained substantial modifications addressing the constitutional tensions Crockett had identified. The revised amendment maintained the principle of state primacy in election administration while adding explicit language preserving congressional authority under the Reconstruction Amendments. Section 3's strict scrutiny requirement had been replaced with a more nuanced, heightened scrutiny standard that better aligned with existing federalism jurisprudence. And Section 4 had been modified to address the retroactivity concerns Crockett had raised regarding pending litigation. In a joint press conference announcing the revised amendment, both members emphasized different aspects while acknowledging their collaboration. Hawley highlighted the preservation of state primacy in general election administration, while Crockett emphasized the strengthened protections for voting rights enforcement. This balanced presentation, each maintaining their constitutional principles while acknowledging the legitimacy of the other's concerns, represented a model of how substantive legal disagreements could be productively navigated. For constitutional scholars, the revision process itself became worthy of study. Harvard Law Review published an analysis titled "Constitutional Dialogue in Practice: The Hawley-Crockett Amendment Process," noting that the evolution from Hawley's original proposal to the Hawley-Crockett revision demonstrates how substantive constitutional critique and practical litigation expertise can refine constitutional text to better harmonize with existing constitutional structures. Perhaps most significantly, the Crockett-Hawley exchange catalyzed a broader conversation about legal credentials versus practical expertise in constitutional interpretation. Editorial boards across the country published thoughtful analyses examining how legal education and practice shape constitutional understanding. Representative Crockett's experience litigating the constitutional provisions at issue proved more valuable than Senator Hawley's prestigious credentials, wrote a constitutional scholar in The Atlantic. This raises important questions about how we evaluate constitutional expertise. Are we overvaluing elite institutional affiliations at the expense of practical litigation experience? And what does this suggest about diversifying the perspectives that shape constitutional development? 6 months after the confrontation, its impact continued to resonate in legal education circles. Several top law schools announced initiatives to incorporate more practical litigation experience into their constitutional law curriculum, explicitly citing the Crockett-Hawley exchange as demonstrating the importance of practical application alongside theoretical understanding. Yale Law School Dean Heather Gerken acknowledged this shift in legal education philosophy. While we're proud of our theoretical traditions, the Crockett-Hawley exchange reminded us that constitutional interpretation requires both doctrinal understanding and practical application. We're expanding our constitutional litigation offerings to better prepare students for the kind of substantive analysis Representative Crockett demonstrated. The legislative impact extended beyond the specific amendment. When a major voting rights bill reached Congress the following year, the drafting process explicitly incorporated what had become known as the Crockett method, identifying potential doctrinal conflicts early and addressing them through specific textual solutions rather than general savings clauses. For those studying constitutional development, the Crockett-Hawley exchange and subsequent collaboration became a case study in effective constitutional dialogue. The Congressional Research Service published an analysis titled "From Confrontation to Collaboration: The Crockett-Hawley Model of Constitutional Refinement," documenting how the initial confrontation ultimately led to stronger constitutional text through substantive engagement rather than credential-based authority. 3 years later, when a modified version of the Hawley-Crockett Amendment was ratified by the required 3/4 of state legislatures, both members were invited to speak at the ratification ceremony. Their joint remarks, Hawley emphasizing the amendment's protection of state authority and Crockett highlighting its preservation of federal voting rights enforcement, demonstrated how their initial confrontation had evolved into a constitutional partnership that strengthened rather than weakened the amendment's legal foundation. For legal practitioners, the confrontation and its aftermath offered a powerful reminder that constitutional expertise comes in many forms beyond prestigious credentials. A prominent law firm hiring partner later observed, "We've started looking more closely at actual litigation experience rather than just law school pedigrees." The Crockett-Hawley exchange showed that understanding how constitutional provisions actually function in courtrooms is at least as valuable as theoretical knowledge of original meaning. The lasting legacy of the confrontation wasn't personal victory or defeat, but a model of how constitutional dialogue should ideally function. In an era often dominated by partisan positioning and credential-based authority, the Crockett-Hawley exchange offered a glimpse of substantive constitutional development focused on doctrinal clarity and practical application, rather than institutional pedigree or political advantage. As a senior constitutional scholar observed, 3 years later, what began with a dismissive reference to Yale law ended with a stronger constitutional amendment that better harmonized with existing constitutional structures. That's not just a personal triumph for either legislator, it's a victory for constitutional development when it functions as the founders intended. If you found this analysis valuable, don't forget to like this video and subscribe to our channel for more in-depth coverage of today's most important constitutional developments. Leave a comment below, sharing your thoughts on how credentials and practical experience shape effective constitutional interpretation.